Welcome to Keeping Faith with the Constitution, a debate between Pam Karlan and Nicholas Quinn Rosenkranz, moderated by Dahlia Lithwick. I'm Kara Stein. I'm Associate Director of Programs at the American Constitution Society for Law and Policy. For those of you who aren't familiar with ACS, we are a national network of lawyers, academics, policymakers, and law students that promotes the vitality of the U.S. Constitution and the fundamental values it expresses: individual rights and liberties, genuine equality, access to justice, democracy, and the rule of law. I first really want to extend our sincere thanks to the Open Society Institute for hosting us, and especially its Washington office director, Stephen Rickard, and Nikichi Taifa, our friend. And we have a really exciting program for you tonight. In August, Oxford University Press reissued an important book initially published by ACS last year called Keeping Faith with the Constitution by Goodwin Liu, Pam Karlan, and Chris Schrader. And Keeping Faith makes the case, first espoused by Chief Justice John Marshall, that the Constitution was, quote, intended to endure for ages to come and consequently to be adapted to the various crises of human affairs. And we're delighted to have Pam with us tonight to talk about the book, and you should all know that she's going to sign copies afterwards out in the hallway. And I'm not going to read you all the details of her illustrious credentials, since Pam is no stranger to ACS, and you have all the speaker bios with you in the handout that you got when you came in. But Pam, as you likely know, is the Kenneth and Harl Montgomery Professor of Public Interest Law and the co-director of the Supreme Court Litigation Clinic at Stanford Law School. And we're also delighted to have Nick Rosenkranz with us, who will challenge, we hope, some of the ideas that Pam writes about in Keeping Faith. Nick is an associate professor of law at Georgetown Law Center, who, it just so happens, is visiting this semester at Stanford. So contrary to the common notion that what happens in Washington stays in Washington, this is going back to Palo Alto, whatever happens tonight. We could not have a more deft moderator for us to navigate these waters than Dahlia Lithwick. She's a senior editor and legal correspondent for Slate, writes the column Supreme Court Dispatches, and was awarded the Online News Association's Award for Online Commentary in 2001. Please join me in welcoming Dahlia, Pam, and Nick.
Well, thank you very much. Can you all hear us? Are these mics bananas? Okay. You can barely hear us? Okay. So I'm going to, if I hold that, is it better? No. Okay. Let's
just speak louder.
Okay. I'm going to speak loudly. And then, can you hear me now? Okay. So I also want to thank ACS and the Federalist Society and the Open Society for inviting us all to be here in celebration of the Constitution. And to just tell you, weirdly, I was rereading the book the other day and came away with the stunning, chilling feeling that, man, the Constitution is cool. What a great document. And I know that probably precludes me from ever being on So You Want to Dance with the Stars. I don't think you generally offer up that opinion, but it's a really incredibly, incredibly thoughtful book. And I think Nick will have incredibly thoughtful responses. But I just wanted to start by reading you a tiny snippet of what then General Kagan, now Justice Kagan, said in response to the question at her confirmation hearings this summer about original intent. She said, "There are some circumstances in which looking to the original intent is determinative, and other cases in which it is not." And then she said, on being asked about textualism, judges should always look to the text, but the text is subject to one or more interpretations, and in some cases, original intent is unlikely to solve the question because it is unknowable. So, in other words, Justice Kagan, now Justice Kagan, confirmed that which we all know, which is that originalism is really important except for when it's not. And this seems to be now the formula that you use at your confirmation hearings, although I did want to just start with the precatory note that it seems to me that in the last two hearings, the questioning about constitutional interpretation was much more ferocious and fraught than the questioning on a lot of substantive law. And that, I think, tells us a lot about how fierce the debate about how we look at the text and the meaning of the Constitution has become. And so without further ado, I'm going to ask each of the two panelists to present sort of opening remarks, their thoughts about, just set the table for us on constitutional intent and interpretation. And I'm going to leave lots of time at the end for your questions. but we'll try to have the first part of this be a moderated debate. So, Pam, I am delighted to welcome you and ask you for 7 minutes on constitutional interpretation. Go.
Well, I'm going to be talking about the Constitution now, and what I'm going to tell you about a lot of this is the week, I think, that maybe we should focus most on the Constitution in some interesting ways, because it's both the week in which September 17th, which is the anniversary of the Constitution Day occurs, and it's, of course, also the week of September 11th, which has put a number of important and powerful strains on the Constitution. Now, when Dahlia said earlier that she read the book and she got these chills because the Constitution is actually a pretty great document, she's talking about not the Constitution of 1789, she's talking about the Constitution we have today. And the question of how we got that Constitution is a lot of what the book Keeping Faith is about. Because the words that were on the page in 1789 were, as Justice Marshall said at the bicentennial of the Constitution, a deeply flawed document. Flawed not just because the document expressly recognized in a kind of hint, not nudge way the presence of slavery in the United States, but also because it didn't recognize some of the rights that we now consider to be absolutely essential to having democratic self-government. And the Constitution, one of the points of the book, is the Constitution was not just made by courts interpreting the Constitution or by people changing the words in the Constitution through amendment, but also by people who gave the Constitution life. And so it's wonderful to be here to talk about this with you today, because some of those people who gave the Constitution life are actually in the room. I mean, if you look at Paul Smith and the Lawrence against Texas case, or you look at LaShawn back there, who was responsible for shepherding the amendments to the Voting Rights Act in 2006 through. If you look at Alan Morrison, who changed how we understand separation of powers or how we understand commercial speech, well, that's one of the major points of the book, is the Constitution. The reason we're having Constitution today is not because of what happened in 1787 or 1789 or 1868, but because of what we have made the Constitution, not just through judicial interpretation, but also through popular interpretation of the Constitution. Because much of constitutional law today, particularly for people who are progressives, is not about what does the Constitution command, but what does the Constitution permit and authorize the government to do. So no one today is arguing really seriously that there is a constitutional right to health care. I mean, there are countries that recognize that, but the United States doesn't, and no one's making that argument. The real constitutional question today, for example, about health care is whether the federal government has the power under the Constitution to provide health care. There is no real question today that the Supreme Court is not prepared to recognize that discrimination that's unintentional violates the Constitution. The question there is whether Congress can pass statutes that prohibit voting practices that have a disparate impact or employment practices that have a disparate impact. And so much of what our book is about is talking about the Constitution we have. How did we get there? And it's designed to show that many of the methods that have become in vogue in recent years cannot explain the Constitution that we assume we have. So, for example, and Nick has written a really wonderfully interesting article about this recently, the First Amendment talks about Congress shall make no law. And yet we assume that the executive branch also has to respect freedom of religion and freedom of speech. And we assume that the 14th Amendment applies not just to the states but to localities. So textualism can't really explain the Constitution that everybody assumes we have, nor can originalism by itself. I think today everybody would assume it would be unconstitutional to deny women the right to practice law. And yet, the original Constitution clearly didn't do that, and the Supreme Court unanimously so held that nothing in the 14th Amendment protected a woman's right to practice her profession. And so what we try to do also in the book is to explain that no one method standing alone will give you all the answers or will explain the answers that we have come to understand our Constitution to embody. And the book is written in language that's designed to take seriously a line of Franklin Roosevelt's, that the Constitution is not a lawyer's document, but the people's document. And so we wrote it in a way that I think lawyers can understand and enjoy, but it's also designed so that just ordinary people who are interested in the Constitution can pick it up and read it and understand why it is that the Constitution's values of equality, liberty, access to justice, and providing the government with enough power to actually protect people's lives is not a betrayal of the Constitution, but actually is the best way to honor it. Is that 7 minutes?
Yeah, that was outstanding. Very well done.
Good, now I can breathe.
Nick, do you want to rebut, refute, address, agree?
Sure. So I'll just talk a bit maybe about the book and my reactions to it. So first, thanks so much for having me. I've never spoken at an ACS event before, but I'm delighted to be here. I can tell you from the perspective of the Federalist Society, our view is that imitation is the sincerest form of flattery. So we're delighted that you're adopting some of our formats, and particularly delighted that you're adopting debates. So the Federalist Society, big believers in debate, big believers in the idea that zealous advocacy on both sides is the best way to get to truth. Too often in our law schools, we don't actually get to hear both sides. So I think it's great that you all are doing that. I'm delighted to be here, and I'm particularly honored to be here with Pam Karlan. I think she's one of the most thoughtful constitutional scholars on your side of the aisle, and it's a
Best in breed, not best in
So it's a pleasure to be here. So a couple reactions to the book. First, I really enjoyed reading the book. I want to urge you all to go and buy a copy afterwards, and Pam will sign it for you. And for the first 20 or so who do that, I will throw in a copy of my recent article as well for free as a bonus. So you can have one of those to enjoy as well. Okay, so the book. The big news is the book rejects expressly living constitutionalism. So describing our Constitution as a living document unduly minimizes the fixed and enduring character of its text and principles. Hurrah. So we agree about that, and I think we're off to a great start. The book is attempting to develop a third approach. So not originalism, not living constitutionalism, but a third thing. And a crucial axiom of this third thing is that the method, quote, does not give judges unchecked power to determine what society's values are or to impose their own values on society. It is not a license to disregard text or precedent or to undermine the rule of law. Of course, that's great news. And that's something that every theory of constitutional interpretation has to say, right? So you will always hear every judicial nominee say words like those words. No judicial nominee is ever going to say, I take the job to be imposing my policy preferences, right? Okay, so that's all good to hear. I read with interest to see quite how this method does that, the way in which this is not judges imposing their policy preferences in the name of constitutional law. To put it another way, to what extent does this method act as a constraint on judges? To what extent does it act as a constraint to at least occasionally, right, occasionally, sometimes decide a case contra their policy preferences, right? If you find that your theory of constitutional law brings you to what you would prefer as the right policy answer every single time, it seems like maybe you're not doing constitutional law, right? So you should check yourself maybe and see if your method occasionally takes you to a policy preference you don't like. Okay. First signs in the book are promising. The book is taking constitutional text seriously. Here is one of my favorite passages. Quote, in our legal culture, it's often argued that fidelity to the Constitution requires constancy in interpretation, whereas change betrays infidelity. This rendition of fidelity may be valid when the object of interpretation is one of the Constitution's concrete and precise commands. For example, all bills for raising revenue must originate in the House of Representatives. Military appropriations cannot last more than 2 years. The seat of the national government may not exceed 10 square miles, and no person can be elected president more than twice. Okay. Now the passage goes on to say, when it comes to provisions that are phrased as broad and general principles, change rather than constancy in interpretation may be necessary to preserve constitutional meaning over time. But let's set that aside for a moment. Just focus on those first examples. At least when the text is concrete and precise, it seems that we're going to take that text fairly seriously. Now, I admit I'm made a little nervous here in that first sentence. The rendition of fidelity may be valid when the object is concrete and precise. So we don't get quite a full endorsement of textualism, even for the concrete phrases, but I'm hopeful. I'm hopeful after that. But so let's start with an easy case. The Seventh Amendment says, in suits at common law where the value of controversy shall exceed $20, the right of trial by jury shall be preserved. And the book says some protections have determinate language, for example, the $20 threshold. Okay. But on the method endorsed in the book, you might think that what you want to do is derive a principle from that rule. What's the underlying animating principle? And interpret the clause per the principle. In fact, this would seem like one of the easiest cases for that method. So very easy to figure out what the idea was of this $20 business, right? I mean, the idea clearly was if the dispute is de minimis, we shouldn't be wasting jurors' time, right? So we'll just have some threshold. If it's trivial amount of money, then we're not going to waste the time of the community on deciding the suit. Okay, but and also, it's quite easy to see how you would update that provision if you wanted to. So you could just update it per inflation. You'd say, well, the idea is de minimis, but $20 was de minimis then, but $20 now is worth, $250, and so the right way to read that thing is in suits above $250, right? This seems to be an easy case in a way for the application of this method, yet I suspect nobody thinks we should do that. So I bet no one here thinks we should do that. I bet Pam doesn't think we should do that. I suspect the answer is $20 equals $20 for everybody. And so I'd ask you to think about why. Why is that? Why do we think the text wins when it's crystal clear, even if you think it's dumb? I mean, even if it's kind of a dumb rule, $20 now, kind of a dumb rule. Okay. Second example, the First Amendment. Congress shall make no law respecting an establishment of religion, prohibiting the free exercise thereof, etc. Now, obviously, this is a much harder provision to interpret. It's got these abstract nouns, speech and press and religion. What do these things mean? These are difficult words. They pose interpretive problems for originalists and for non-originalists. But one word is crystal clear. The first word, Congress. I want to submit it's even clearer than the $20 provision. Why is it clearer? Because it's actually a defined term in the Constitution. The Constitution actually tells you who Congress is and tells you prominently. Article 1, Section 1, first sentence, starts off telling you about who exactly Congress is. So why doesn't the clear text win in that case? The book just asks us, rhetorically, the book says, the Constitution contains phrases that do not bear a literal reading. Does no law really mean no law, no exceptions? And does the directive to Congress mean the First Amendment should not be read to apply to the president or the states? Just rhetorical questions. I take the answer to these rhetorical questions supposed to be no, but I'm not sure why that is. I'm not sure how we distinguish that from the $20 case. So you might think the distinction is the $20 case is an expansion of rights. So with inflation, the right to a jury trial grows, whereas if we limit the First Amendment to Congress, that's like a shrinking version of the First Amendment. But consider also this, does no law really mean no law business? So so the book is suggesting a broader reading of the First Amendment vis-a-vis who it applies to, but actually kind of a narrower reading vis-a-vis what it's prohibiting. So the distinction's not quite broad versus narrow. It's how are we doing? Are we?
I think we're there.
Yeah, we're almost there.
Do you want to?
Yeah,
Let's let Pam respond, maybe, or wrap up, and then we'll let Pam respond. How about that?
Yeah. So, well, why don't we start with that? So, are we taking is crystal clear constitutional text dispositive? Could we agree on that? I guess is what I'd want to ask.
I think the answer is yes, if it's crystal clear. Part of the difficulty is that sometimes the words are standing in for a broader concept. So if we understood that the president can't make law at all, which I think would be one understanding of separation of powers, it's not the American understanding. The president makes law all the time. And at that point, the question is the fact that it's law that's being made more relevant to whether or not the law is constrained by restrictions on whether it can infringe press freedoms or religious freedoms, or is it more about Congress? That is it mostly, the First Amendment, for example, is not in Article 1 of the Constitution, it's in its own amendment. And so one of the issues there is, what was it that the framers were getting at when they talked about freedom of religion? Were they unconcerned that the president would do it? Well, maybe they were unconcerned because they didn't think the president was going to have nearly the power he had. And once the president derives that power, the understanding of what the amendment binds has to change. Now, you asked a question earlier that I did want to respond to as well, which is, and I think that Nick is asking exactly the right question here, which is, a theory that always gets you the answer you would like to get as a policy matter is not really much of a theory. So the question is, can I come up with things that I think are terrible, that are constitutional, or things that I think would be wonderful that are unconstitutional? I'll just give you two examples. I think Congress's commerce power allows them to pass the kind of federal drug laws that we have, that make it a crime and make it a serious crime and put lots of people in jail for a very long time. I think those laws are terrible. But I don't think they're unconstitutional, because I think Congress's commerce power extends that far. Or I think it would be great if the United States, like many other countries in the world, recognized a right to health care as part of its Constitution. I don't think that right is in the Constitution. I think that if Congress had not passed a health care bill, you could not go into federal court and bring a lawsuit saying, I need health care, I'm not getting it, the government is violating my rights. Because I do think there are some real constraints on what the Constitution commands and on what the Constitution prohibits. But I don't think that the text alone necessarily tells you things without looking at it in context. So let me just use an example I like to use with first-year law students, because it makes it really clear to them. The Constitution says that no one can be the president of the United States unless he's a natural-born citizen. Now, we all know we're having all of these problems now with the birthers and Barack Obama. The interesting thing, though, is even the people who hated Bill Clinton with a white, hot, burning hate and thought he was Satan incarnate did not argue that he was disqualified from being president because he was delivered by cesarean section. Now, why is that? It's because even though, if you go back to Macbeth, they talk about, no man of woman born, everybody understood natural-born citizen was in contradistinction to naturalized citizen. It was not, in distinction to the untimely ripped. And so even those words require at least a little bit of interpretation. But I admit the theories, no method binds you across the board. And one sort of last point about this, which was last term the Supreme Court had two cases. I'd be really interested, Nick, in sort of how you think about how these cases went. But the court had two cases last term in which originalism could have made a real contribution to the debate. One of them was the McDonnell case, which is the Chicago guns case, and the question of, first of all, whether the Second Amendment applies to state and local regulations at all, and if it did, and everybody knew it was going to, why does it apply? Is it because the Liberty Clause of the Due Process Clause of the 14th Amendment incorporates the Second Amendment? Or is it because bearing arms is a privilege and immunity of citizenship protected by a different piece of the 14th Amendment? Now, I think there's a very real historical debate about what those provisions meant and how they applied to guns. But with the exception of Justice Thomas, every other justice threw that under the bus. And Justice Scalia was forced to decide between how much did he hate substantive due process versus how much did he hate recognizing new rights versus how much did he hate laws that were restricting gun ownership in the home. And the one that lost out there was originalism. Similarly, in the term, the Supreme Court decided a case called Doe against Reed that involved the question whether people who sign petitions for initiatives can keep anonymous the fact that they signed. Justice Scalia wrote what I think was an extremely interesting, deeply persuasive historical argument that whatever the explanation for the secret ballot, it can't be a historical understanding of the First Amendment because the people who ratified the First Amendment voted in public. They all got up and put up their hands and said, this is the person I'm voting for. So there was no secret ballot. They couldn't have understood that the First Amendment required it because they kept on voting that way for another 100 years. Very interesting, very historical, originalist. The other 8 justices just threw it under the bus. And so no method is going to constrain all the time. What's interesting is when do you leave the method behind and when do you use it? And I confess I feel really bad about this in a way. I don't have a constitutional method. I mean, I don't just pick and choose randomly, but I look at all of these different things when I try to figure out whether some law Congress passed is constitutional or whether some action a state government took is unconstitutional. I guess I can't do much better than that. But.
Do you want to do Doe v. Reed, or do you want to do McDonald, or do you want to tell us what you do when originalism runs out? Or you can just do something entirely different. But go.
Well, I guess I'd just say that there are, of course, hard cases, and there are hard cases for all of us, and there are hard cases for every method. The thing, and I'm sympathetic to the project of trying to bring these different tools to bear on these difficult cases. I think we kind of agree that many of these different things should be relevant to the inquiry. So. We have here in the book an endorsement that we ought to start at least by taking a look at what the words of the Constitution say. We have an endorsement that history matters. We ought to look and see what the historical pedigree is. So, in some sense, we're talking about differences in emphases, I guess. And my concern is really just being a bit too quick to set the text aside or throw up our hands and say, it looks like this one's one that's indeterminate, and so I'm going to have to apply my sense of the animating principles or something, which we can easily talk in kind of constitutional sounding rhetoric about liberty and equality and important resounding ringing principles, but I get nervous that what's going on there under the surface is the liberty and the equality that you like, but maybe not the same liberty and equality that I like. And I can wax rhapsodic about economic liberty in the same way that you can wax rhapsodic about privacy. And I'm not sure quite that we're really having a debate other than a policy debate.
Yeah, although the interesting thing there is that if you and I were living in 1810, we'd be so old today, but if you and I were living in 1810, I might be persuaded by a number of the arguments you make, because at that point, for example, an argument that says the First Amendment says Congress, so it can't possibly mean the president too. If the people who had proposed it had meant to bind the president or restrict his ability to impose on people's religious liberty. And right now, the president actually has all of these different ways of doing that. I mean, imagine that the president just decided to fire a bunch of people because they were Muslims, or in his case, fire a bunch of people because they're not Muslims, I guess is what people would be worried about. Or, the federal government runs a huge prison system. There aren't really many laws that say very much about what should go on inside the prison system. So if they started firing guards because the guards exercised their First Amendment rights off the job and were voting for the other political party, or well, that all is important stuff today that wasn't true then. And we have come to have an understanding. That is, we have come to have the understanding that the word Congress doesn't have the meaning of being restricted to just Congress. And so I'm not interpreting on a blank slate. If I were interpreting on a blank slate, a new provision, I would have to look at the text in a different way than I would look at the text when I'm interpreting a provision where I don't go back to first principles each time I think about a constitutional issue. I ask also, what have these words come to be understood to mean over time? And some of that is a judicial gloss that I'm not willing to go back and completely unpeel.
I wonder if I can just ask. I mean, you're pretty. Oh, my pen just. Okay, you're pretty forthright in the introduction to the book that look, we've been losing the PR battle on this. I mean, originalism. Polls show that Americans, for all the reasons that Nick say, really want their judges to be constrained, and the more constrained, the better. Is that something that constitutional fidelity answers to, or is it in fact another way of saying, look, just trust us. Just trust us as judges. We're taking 7 things into account, not just 1, but we're not basing our decisions based on what we had for breakfast.
Well, people do want judges to be constrained, but people also want judges to interpret the Constitution consistent with what they've come to understand the Constitution to mean. So if you had a judge who tomorrow got up and said, I've gone back and looked at the 1868 ratification debates, and one thing we do know, because they put it into the Constitution in the 14th Amendment itself, in Section 2 of the 14th Amendment, which no one ever reads anymore, which it contains something called the Reduction of Representation Clause, which says essentially if a state gets a bunch of seats in Congress based on its population, and then it disenfranchises male citizens over the age of 21, they'll get some of their seats taken away from them. And the Supreme Court in 1875 read this to say, well, they put the word male in there for a reason. They didn't expect women were going to have the right to vote. They didn't really believe in women's equality in 1868. So if a justice were today to say, I am constrained by the words and the original meaning of the words, and therefore, although this particular state is discriminating against women on the basis of sex, there's nothing wrong with that in the Constitution. People would not think that was a judicial constraint. They would think that's judicial activism. And this is part of what we try to get at a little bit in the book, is the buzzwords about judicial constraint, judicial activism, and the like are just that. There was a wonderful, in 1948, somebody asked Bertrand Russell to explain how you conjugate an irregular verb, and he gave the following example, which is, I am principled, you are obstinate, he is a pig-headed fool. And the New Statesman, which is a magazine in Britain, had a competition where people could come up with other examples like this. And my favorite one is, I have the mystery of the Orient about me, you kind of overdid it, she really stinks. Which was a kind of about perfumes, if you couldn't figure out what that was about. So here's the thing. I have principles. You are result-oriented. He is a judicial activist. It's exactly the same point, which is at the point at which you have confirmation hearings where people are suggesting that they're worried that Justice Sotomayor will be a judicial activist because she permitted New Haven to change its promotion system, then I don't know what judicial activism means. Or when you have people saying, we are worried that Justice Kagan will be a judicial activist because she's probably going to refuse to strike down gun laws, then I don't know what judicial activism means. Or people who are worried that the Supreme Court doesn't aggressively employ the takings clause are judicial activists. I don't exactly know what it means, except I do not like what you are doing. Therefore, it's judicial activism. And so Judges are constrained by the culture in which they work, by the times in which they live, by the cases that have come before, by popular understandings of the Constitution, by the structure of the Constitution, by the consequences. I mean, even Justice Scalia in the first of the guns cases, the Heller case, said you don't have the right to take your gun into a public building. But of course you have the First Amendment right to go into a public building and wear a jacket that says fuck the draft. How can the First Amendment give you that right and the Second Amendment doesn't allow you to take your gun in? Because of the consequences. And so all of these things play into how judges are going to interpret the Constitution. They're not judges are not like free range, free range judges, free range organic judges out there just pecking around doing whatever they want. That's not really what judges are. They are constrained in a lot of ways, but not just by the text.
Do you want to respond to that?
Yeah, so a theme of the book and a theme of those comments is that we want to interpret, the people want their Constitution interpreted in the way that they have come to understand it. And so there's kind of an odd feedback loop to that idea. So the Constitution is going to be a constraint on judges, but there's a strain of counter-majoritarianism to the whole idea of judicial review, but then there's a strain of majoritarianism to the idea that somehow interpretations are vindicated or validated by the fact that we all have come to see the wisdom of them or something. We've all have come to agree that we're happy to live in a country where that's the rule or something. And I guess I get a little nervous about that being a kind of a standard or a check mark for whether we've hit on the right interpretation or not. I wonder if we're going to use that selectively or not. So the book celebrates the end of the Lochner era, 1937, and says what. The people had come to understand, we had all come to understand the great importance of government regulating the economy. And and how unfortunate it was that government couldn't do things like impose minimum wage laws, things like that. And we had all come to realize that. And so then Lochner was repudiated, and that is a happy story in the book. Now, so we're at a moment when tens of thousands of people are gathering on the Mall to say they think that's wrong. Right? They think actually government is interfering in the economy too much, and they think that's wrong. And it's a kind of a popular movement, the likes of which we haven't seen in decades. Actually, is kind of reminiscent of what was going on in the 30s when there really were popular constitutional discussions. I mean, the Tea Party movement really is, actually they're taking the Constitution pretty seriously. I mean, to the extent that they have an agenda, at least purport to be advancing a particular constitutional agenda. So now, and also by all accounts and all polls, looks like we may be on the verge of some kind of historic landslide election here in a couple of months. Okay. Should that have constitutional consequences? So all those Tea Party folks win all their elections, let's assume, in November. I would think and assume that they'll try and roll back some economic legislation, and that's as it should be in a democracy, and I'm sure everybody thinks that that's their prerogative to do if they should win some elections. But does it also follow that that is a kind of vindication of Lochner? That now actually not only should we roll back these regulations, for now, but actually the Congress is now going to be constitutionally forbidden from enacting such legislation in the future. States will be forbidden from enacting such legislation in the future. It's hard to imagine that I guess I'd say I'd be surprised to hear you advancing that story about the Tea Party movement.
I think, though, I would advance that story, which is if you win enough elections in a row, you will change the popular culture, you'll change who the president is. The president will decide to nominate people to the courts who have a view of the Constitution that fits with that understanding, and the Constitution will, the Liberty Clause of the Constitution will be interpreted differently. I think that's one thing you have to recognize if you take the view of the Constitution, which we do, which is that the Constitution has broad principles, but how those principles come to be understood is a function of popular movements. The women's movement changed our understanding of the Constitution. The civil rights movement changed our understanding of the Constitution. And if the Tea Party movement turns out to have that staying power and to have that that kind of intellectual power and to draw enough people in with its moral force, then they are going to change the Constitution too. It may turn out to be a country that I don't want to live in, and luckily I'm old enough that I'll probably be dead by then anyway. But I'm prepared to, I think this goes back to your initial question. Live by the method, die by the method. If the Constitution, if liberty comes to be understood as not about whether the government enables your kids to go to school and get a good education, but whether you get to keep everything you make and sit in a house with a gun and blow anybody away who comes by to try and make you buy health insurance, then, that's what it's going to be. And I really am prepared to recognize that.
I think that's Sarah Palin's campaign slogan.
But so just to ask,
but I think one of the things, just to say one last thing, which is I think one of the things that those of us who are on the other side of these debates have to do is to explain to people, get the government out of my Medicare is not a coherent slogan. But I am prepared to recognize that if people come to recognize economic liberties as the most important liberties we have, our interpretation of the 14th Amendment over time will change. And I've got to live with that.
I guess I have to understand the difference between will and should here. So it's surely descriptively true that if Sarah Palin is elected, she'll nominate some justices, and they may change some constitutional doctrine, and so the doctrine will descriptively change. We of course agree about that, but it seems at times like you're saying it should. That is that actually the right answer changes because the Tea Party has won a couple of elections.
I think to some extent, to some extent, I agree with that. That is, people have to argue about what these phrases in the Constitution, like equality, means. That is, our understanding that men and women should be equal before the law today is a different understanding than they had in 1868, and that's a good thing. I think that's a good thing. If at some point, long down the road, again, I don't want to die soon, but I want to die before this happens. If at some point in the future we decide that, life begins at conception, and therefore the state has a duty to protect the life of every fetus, well, then that's going to be a change too. And I think the Constitution was designed in a way that allows us to ask, what does liberty mean today? We understand liberty differently than we understood liberty in 1789 or 1868. And I guess the difficulty here with the kind of should, does, the is, ought distinction is one where I don't have a super strong sense of it. What I do know is the only way to explain the Constitution we have is to say the Constitution we have is the product of changes in popular and judicial understanding of what some of those words should mean given the context in which the particular constitutional issue arose. Now, should it be that way? I think yes, because I think otherwise you can't have a constitution that endures as long as ours does. There was a study by Tom Ginsburg, who's a political scientist who's now at the University of Chicago, where he showed that the average lifespan of a national constitution is 17 years. And part of the reason for that is governments, they write these constitutions that are incredibly specific. And then you look around and it's like, if you buy a bicycle for a small child, it's not going to fit them a couple of years later. And so they have to go back and rewrite their constitution. Now, we don't do that in the United States, but that's because our constitution is more capacious. But in that capaciousness is the risk that you will end up with people recognizing rights that you don't really think ought to be recognized, and failing to recognize constraints that you really think are in the document. And I guess I don't see the alternative.
I'm gonna give you a minute, and then I'm gonna take questions because I know we want to sell books. So
I don't want to sell books. I wanted to give them away. That's why we had the ACS version, which you can still download for free, by the way.
Pam. All right.
Just another self-inflicted wound there.
Nick, why don't you address that, and then we'll take questions.
Sure. So if it is legitimate for Sarah Palin's nominees to change the Constitution by interpretation in a direction that you don't like, I don't really understand how you are going to, at that moment, how you're going to criticize those nominees other than by saying, I don't like the policy result. It's a country I won't be happy in. And that doesn't sound like constitutional discourse. Are you not going to, when those nominees are testifying, you're going to be writing things along the lines of, this nominee has it wrong, has gotten this wrong. But how are you going to say that when, if the nominee gets through and changes the interpretation, that is as legitimate as any other change?
I'm going to say that you shouldn't confirm the person because they have the wrong views. If they get confirmed, they're going to be affected by their views.
They have the wrong views or the wrong constitutional method?
Both. They have but I don't think it's mostly the method, which is what happens if I say the word equality in the Constitution means gender equality. Gender equality is contained within the Equal Protection Clause. And they say, well, I don't think it is. I can talk about method. And if they say, I'm an originalist, I don't have a response. Okay? I don't have a response to that, which is, if you really are an originalist and you say in 1860, and I don't look at anything that happened after 1868, and I look in 1868 and there's no gender equality there, well, I don't have a response to that other than to say, I don't like your method, because I think that you ought to also look at changed social understandings and the precedent that's grown up. But if you are uninterested in precedent, and you're uninterested in popular understandings of the term, then I don't have anything to say to you other than we disagree. I mean, and I think we just have to recognize that the method is not, the arguments over method are important, but also the arguments over what the principles in the Constitution are. What is the balance between liberty and security? That's going to be struck differently by different people. What is the balance between equality of results and equality of opportunity? That's going to be struck differently by different people. But I think to pretend to people that there's one good method out there and that if people honestly applied that method, they would all agree on every issue is fantasy. I mean, I just don't think that's going to happen. So, of course, I would tell people, vote against nominees who don't share your constitutional vision. I don't have a problem with saying that. But beyond that, I don't know what I can say. And I don't know what people on the other side can say.
Can I?
Yes. We don't want to end on existential despair.
Existential despair. I mean
I'm
pretty
joking.
Despairing, but not existentially.
So there's a paragraph in the book that is that I have here that is along these lines. So over the decades since Roe, our society has deepened its understanding of constitutional underpinnings of the right to reproductive autonomy. Some judges and commentators, most notably Justice Ginsburg, have sought to locate the right not only in the liberty protected by the Due Process Clause, but also in the gender equality component of the Equal Protection Clause. Still others have sought to reinforce the right by arguing for a revival of the Privileges or Immunities Clause of the 14th Amendment, or by relying on First Amendment-based protections for freedom of conscience. The reasons for this evolution are not just or even primarily a tactical desire to shore up what might otherwise seem a vulnerable result. Whatever the virtues of these alternative rationales, it is unlikely that anti-abortion forces will be convinced to abandon their opposition by a shift in doctrine. So now I began with my favorite passage in the book. This, I think, is probably my least favorite passage. And the reason is it's the quickness to kind of throw up your hands about the text. So whatever the virtues of these alternative rationales, that is, I'm not going to tell you which clause actually I think does the work here. It's unlikely that anti-abortion forces will be convinced. In other words, they're really just doing politics anyway, and so don't bother to locate the relevant clause because they're not going to hear you anyway. And I think that's just quick to despair of constitutional dialogue. I think even, you may be surprised to know lots of originalists actually are, pro-choice and would love to hear a kind of reasoned argument in favor of Roe, and are not quite just going, are not quite anti-abortion in a kind of reflexive, policy-driven way, but just want you to point to the right clause for us so that we can actually talk about constitutional text.
See the government clause. No, I think there are people who don't have a strongly held constitutional view about abortion who are subject to, if all of a sudden we found that there was another amendment that had been just Scrivener error left out that said, and women should have reproductive autonomy, they would jump on this. I think, though, that people who are pro-life or who are anti-abortion because they believe life begins at conception, there is no argument that is going to persuade people who take that position that the Constitution provides a right to abortion. In the same way that I like to hope, I would have thought even before the 14th Amendment, even at the time of Dred Scott, I like to think I would have been the kind of person who say, African Americans are human beings, and they are people, and they are citizens, and it doesn't matter whether there's anything in the Constitution that says that or not. And I take seriously the people on the other side of the abortion debate who honestly believe that the fetus is a human being. I don't think that the problem for them is that we made a substantive due process argument rather than an equal protection argument. I don't even think they would be persuaded if we had an originalist argument, because what they would say is then the Constitution, to kind of paraphrase, I think it's William Lloyd Garrison, is a pact with the devil. Right? And I would have, and if they're right about that, then they're right.
Okay, I'm gonna really seriously take questions.
Okay.
Because a lot of people have questions, and I'm going to beg you, because we have a lot of people and a lot of questions and very little time, to ask your question in the form of a question, and with a question mark at the end, and to be as brief as you possibly can. Go ahead.
Ms. Karlan, given your analysis, how would you evaluate the Citizens United case that the Supreme Court recently decided, which now opens the door to corporations to put millions of dollars into election campaigning?
Well, I don't like Citizens United very much, but having been a campaign finance regulator in California, I don't think it really changes the playing field very much. That is, the ways that corporations had to spend money before gave them ample opportunity to spend the money they wanted to spend, and they're going to have that now. I think it's a mistake, for example, the people who want to argue that the reason Citizens United is wrong is that corporations aren't people have got it wrong, because I think corporations are organizations of people, and some corporations are organized for the purpose of influencing politics. On the other hand, I think that corporations can be regulated. So I think the Supreme Court got it wrong. But the thing that I find interesting is the level of outrage over that decision as opposed to other decisions of the Supreme Court. I'm puzzled by it, because I actually think that money in the political system is a lot like water in the Mississippi River. You can dam it up over here, but it's going to keep flowing. And when you dam it up over here, one of the really bad things about campaign finance regulation and the way we've done it is you dam it up over here, and it flows over here, and it causes more damage in some ways than if you had just let it go down the middle of the river. If you go back to 1973, we had a lot of problems with money in politics, but at least the money was going into the political parties, which were big tents and which had to run elections, and they had to be responsive. And now the money has gotten to more and more hidden places, and it's been pushed into ways that have made politics in a lot of ways worse. So, do I like Citizens United? No, I don't. Do I think it's like a disaster? No. I think it doesn't change the playing field very much.
Okay. And wait for a mic. Yeah, go ahead. Back there.
So, what role does technology play in constitutional interpretation, particularly in the Fourth Amendment realm?
Do you want to do that first, or me first, or?
Do you care who answers? Do Do you want to take a crack, Nick? Or?
Sure, I could take a crack. So the Fourth Amendment talks in terms of reasonableness. So to figure out what a reasonable search is, I suppose you have to do some balancing of the costs and the benefits of the search. How intrusive is it? How intrusive is it versus what are the benefits? So what are the odds that you're going to find something, and what are the odds that the thing you find is going to be a really important thing to find? I think you can apply that sort of reasonableness analysis to the technology in Kilo, or I think you can apply that sort of analysis, whatever technological advancements there happen to be. I think the language of reasonableness allows us to apply the thing to whatever the developments happen to be.
I'll say just one word about this, which is I think when you get outside of the Fourth Amendment search context and you're talking about people's understandings of privacy, there are threats that the framers couldn't possibly have imagined. Threats that come from the ability to aggregate data and the ability to then harass people in a way that they couldn't have been. In 1789, if you wanted to harass somebody, you probably had to go pretty much face to face to harass them. And the ability of people on the other side of the country to send, threatening emails didn't exist and the like. And that's why in the Doe against Reed case, one of the things that was so interesting is, Justice Thomas, who is generally the most originalist of justices, said, well, you've got to recognize that there's a problem here, and the problem comes from the fact that people can use computers to disseminate this information and then can use email to harass people. And I think, the understanding of what the threats are is in part a function of what the technology allows. And so even if the word, you can't do unreasonable searches, one of the things that was interesting in the Kilo case, which I always like to call the Kilo case rather than the Kylo case because it sounds so much better when he's dealing drugs, is in 1789 they would not have understood that you were searching somebody if you were standing on public property. Searches required a physical intrusion. But Justice Scalia had no problem, and I think rightly so, saying today you can search somebody's house while you're standing on the street with a thermal imaging device. And so I think the threats that technology poses are a perfect example of why the understanding has changed.
My question is more for you, Professor Rosenkranz.
Rosenkranz, yeah.
What do you make of the fact?
Do you want to get him a mic for a second? I'm sorry, I think just for recording purposes. Thanks.
What do you make of the fact that the framers included the Ninth Amendment, which expressly recognizes that there are unenumerated rights that are reserved to the people, and how judges, are supposed to figure out what those unenumerated rights are? Would you agree with Justice Goldberg's analysis in Griswold that supports privacy or the right to use contraceptives?
So I'll freely admit that I don't have a fully formed theory of the Ninth Amendment, and I'm not sure anyone does in a way that's totally satisfying. That the Ninth Amendment, as you say, that is, you recount it accurately. It's not clear to me that it's talking about rights at the level of constitutional rights that are meant to be judicially enforced. So you could give the Ninth Amendment content and yet not believe that judges are meant to strike down democratically elected legislation per the Ninth Amendment. That seems like that's really the court's view of it now, but I'm just going to confess I don't have a fully formed theory of it.
Well, the only thing I'll say about this, and this is more, I think, in response to Nick's answer, is even if you don't think that the judges should enforce it, it would still be a subject for constitutional argument in the populace. That is, when a state says we want to ban abortion, the Ninth Amendment, in that view, would be something where opponents of restrictions on abortion would come in and say, well, wait a second, this is what we think the Constitution means. And there are lots of pieces of the Constitution that aren't enforced judicially, that get enforced through public understandings all the time. So
Absolutely, I quite agree that the Ninth Amendment should be a part of constitutional discourse in the populace when you're deciding who to elect or what kinds of laws to pass. So I think we agree about that.
We have a bunch more questions and very little time, so I'm going to take Ian, and then I'm sorry.
So, Pam, I just want to. I'm worried about the implications of the lack of understanding of our constitutional debate on your theory. You know, if we roll back the clock to 1991, I think it's very unlikely that George H.W. Bush said to his advisors, "Bring me a nominee who thinks that child labor laws are unconstitutional." And yet, if you read Thomas's concurrences in Lopez and Morrison, it's clear he believes that. I don't think that anyone who voted for Judge Henry Hudson thought, like, this is a guy who's going to think that nullification statutes really mean something, and that's why I'm voting for him. So, if in fact a president campaigns on, I'm going to overturn Roe, and they get elected, and that happens over and over and over again, I'm willing to accept the implications of your theory. But when it all happens in secret, where does that lead us? I mean, how is there any legitimacy to when people don't realize that the Constitution is changing until it's too late?
That is an incredibly difficult question to answer. And I think the only answer I can give is that judges should understand the culture in which they operate and should be modest and hesitant in overturning decades worth of constitutional understandings. This is one of the costs of having a judiciary that has life tenure, and in a country in which people live an awful long time and which they get nominated awfully young. But the costs of not having judicial independence are equally frightening, and you can look around the world and see why that's so. Presidents are usually thinking, over the long historical, they're usually thinking when they nominate people to the courts about the issue that seems most salient in politics at the moment. So, for example, Franklin Roosevelt cared greatly about nominating people who would uphold the New Deal. He did not think at all about what those people would do when faced with claims of racial justice, which is why we are really lucky that Brown didn't come along until a lot of his nominees either had left the Supreme Court. He nominated Jimmy Burns to the Supreme Court, right, who was the governor of South Carolina, who was defending segregation in the Brown cases. We're just lucky Jimmy Burns would rather be a governor than a justice. And I think in the same way, presidents who were nominating people in the early 1990s were not thinking about the questions of national security that are now in front of the courts. But the only thing I can say is rogue district judges get overturned on appeal, and you've got to change enough justices on the Supreme Court to have a majority that not only thinks that the law that the interpretations from before were wrong, but that they were so wrong that stare decisis doesn't play a role. But I recognize that's about the best I can give you.
If I can just speak to that for a second. So I think you're right that people don't necessarily realize that they're voting for a constitutional change when they vote for a president or a senator or something. There is, though, a moment when people realize that they are voting for a constitutional change, and that's when they vote about amendments. It's when they vote about amendments. Now, it's a kind of an axiom of this book that the amendment process doesn't suffice, that we can't quite update the Constitution fast enough and sufficiently for changing circumstances. I'm not sure why that is. The amendment process is, we've actually amended the Constitution an average of once every 8 years since it was ratified, and it's hard but not impossible. And that actually is a moment when the people really focus on what they want their Constitution to say. I think that's bound to be a better, really the best, really the only indication of what the people actually want their Constitution to say and mean. So I'm a much bigger believer in the amendment process than in the updating by interpretation process.
No, I promised that we'd end on time, so I'm gonna ask those of you who have questions still to come up and ask the panelists after we finish. And I want to thank both Pam and Nick for taking the time to really answer thoughtfully today. And I want to urge all of you to race out in the few minutes that are left and buy Pam's book, and then buy Nick's article.
My article's free.
I know. And I want to really thank you all for coming tonight. This was a terrific